tally and declare the results of the election of the president. These stages and responsibilities are so elaborately explained in the judgment of this court that it confounds the mind that the second respondent would pose such a question. The way in which the question is framed appears to be based on the assumption that the results in Forms 34A and those in Forms 34B are mutually exclusive. It is not a rudimentary fact that the latter, is it not a rudimentary fact that the latter is the aggregate of the former? And if this is so, how would it be a matter of choice as to which results between Forms 34A and Forms 34B the second respondent is to declare? Who aggregates that into what? Again, is it not an established fact that the constituency returning officer aggregates Forms 34A from the polling stations into Form 34B? Before generating Form 34B, does not the returning officer verify the figures in Forms 34A? Is it not a fact that the second respondent, as the national returning officer, aggregates the results from Forms 34B into Form 34C? Did this court not categorically state that before declaring the final aggregate results in Form 34C, the first respondent on behalf of the second respondent must verify the said results against those in the transmitted Forms 34A? Is this not why Form 34A is considered the primary document in the verification process? Is the verification exercise not meant to establish the accuracy or otherwise of the results, which is a basic tenet of the Constitution? If the second respondent notices some inaccuracies as brought to his attention by the first respondent, what is his duty? Is he not supposed to simply bring those to the attention of the candidates, the public, and the election observers, even as he declares the final result as aggregated from Forms 34B? What did this court say about the effect of inaccuracies that may be unearthed by the verification exercise on an election? At paragraph F of the notice of motion, the applicant states that despite agreeing with the finding in the minor KI case at paragraph 294 of his judgment, the Supreme Court criticized the reliance by the first and second respondents of the minor KI case for the position that any errors identified by the first and second respondents in the verification can only be corrected by an election court.